Welcome to meeting number 117 of the House of Commons Standing Committee on Access to Information, Privacy and Ethics. Today, the committee is considering the maintenance estimates 2024-2025 for the first hour. Then, the committee will resume its study of the impact of disinformation and of misinformation on the work of parliamentarians for the second hour. And finally, we will end with some time in camera to discuss a few items of business. Before we begin, I would like to remind all members and other meeting participants in the room of the following important preventative measures.
All aware of them. Mr. Dufresne, just make sure if you're not using the earpiece to put it in the proper place. As indicated on the table, we certainly would not want to cause any harm for our interpreters. And so, of course, the room has been adjusted for that as well. So, pursuant to Standing Order 81-4, the committee is resuming consideration of the main estimates 2024-2025, and we'll be dealing with votes after we're done under the Office of the Commissioner of Lobbying, Conflict of Interest and Ethics Commissioner, Office of the Senate Ethics Officer, and the Offices of the Information and Privacy Commissioners of Canada, which were referred to the committee on Thursday, February 29th. I'm going to welcome our first hour, no stranger to this committee, Mr. Philip Dufresne, who is the Privacy Commissioner of Canada. Sir, welcome. And Mr. Richard Rule, Deputy Commissioner of Corporate Management Sector. Commissioner, up to 5 minutes to address the committee. Please start now. Thank you.
Thank you, Mr. Chair, members of the committee. I'm pleased to be here today to discuss the Office of the Privacy Commissioner of Canada's main estimates for fiscal year 2024-25 and to describe the work of my office to protect and promote the fundamental right to privacy of Canadians. I'm accompanied by Richard Roux, Deputy Commissioner, Corporate Management Sector. In January, I launched a strategic plan that lays out 3 key priorities that will guide the work of the OPC through 2027. They include protecting and promoting privacy with maximum impact by using business intelligence to identify trends that need attention, producing focused guidance and outreach, leveraging strategic partnerships, and preparing for the implementation of potential new privacy legislation. Second, addressing and advocating for privacy in this time of technological change with a focus on artificial intelligence and generative AI, the proliferation of which brings both potential benefits and increased risks to privacy. And championing children's privacy rights to ensure that their unique privacy needs are met and that they can exercise their rights. Selon moi, ces priorités stratégiques sont...
I believe that these 3 priorities are where the OPC can have the greatest impact for Canadians, and that these are also where the greatest risks lie if the issues are not addressed. Protecting privacy is one of the paramount challenges of our time. My office is poised to meet this challenge through strong advocacy, collaboration, partnerships, education, promotion, enforcement, and capacity building, which includes doing more to identify and address privacy trends, and doing this in a timely way. Investigations under the Privacy Act, which covers the personal information handling practices of the federal government departments and agencies, and the PIPEDA Personal Information Protection and Electronic Documents Act, Canada's federal private sector privacy law, are a key aspect of the OPC's work on issues that significantly impact the lives of Canadians.
The results of my investigation into ALO, the operator of the website Pornhub and other pornographic websites. I found that the company had contravened Canada's federal private sector privacy law by enabling intimate images to be shared on its websites without the direct knowledge and consent of everyone who is depicted. In releasing my report on this investigation, I reiterated that the non-consensual sharing of intimate images is a serious privacy violation that can cause severe harms to victims, and that organizations have an obligation under privacy law to prevent and remedy this. This case is also relevant to the discussions that will be taking place on Bill C-63, and I will welcome the opportunity to share my views on the Online Harms Act with parliamentarians. J'ai également hâte de diffuser au cours des...
I also look forward to sharing in the coming months the findings of two high-profile investigations that are closely tied to two of my strategic priorities, protecting children's privacy and addressing the privacy impacts of emerging technology, including AI. When I appeared before you last year on Main Estimates, I spoke about the launch of investigations into TikTok, as well as OpenAI, the company behind the AI-driven text generation chatbot ChatGPT. Both investigations are being conducted jointly with my counterparts in Quebec, British Columbia, and Alberta.
Investigation, the four offices are examining whether the practices of the company, ByteDance, comply with Canadian federal and provincial privacy legislation, and in particular, whether valid and meaningful consent is being obtained for the collection, use, and disclosure of personal information. Given the importance of protecting children's privacy, the joint investigation has a particular focus on TikTok's privacy practices as they relate to younger users. Investigation to OpenAI and its ChatGPT chatbot is examining whether the company is compliant with requirements under Canadian privacy law in relation to consent, openness, access, accuracy, and accountability, and is considering whether the collection, use, and disclosure is done for an appropriate purpose. Les deux enquêtes sont d'une grande priorité.
Both investigations remain a high priority, and we are working to complete them in a timely manner. Protecting and promoting privacy with maximum impact remains integral to fulfilling my current mandate and preparing for potential changes to federal privacy law.
2023 budget, we received temporary funding to address pressures related to privacy breaches and a complaint backlog, as well as to prepare for implementation of Bill C-27. While these temporary funds provided necessary and immediate support, it is essential for my office to be properly resourced on a permanent basis to deal with the increasing complexity of today's privacy landscape and associated demands on my office's resources. And so we will
claim here.
Matt, your mic's open there. Sorry, Mr. Dufresne.
Okay. No worries. To address this, we will continue to present fiscally responsible funding requests, and will also aim to maximize agility and cost effectiveness by assessing and streamlining programs and service delivery. And with that, I will be happy to answer your questions. Thank you.
Okay. Thank you, Mr. Dufresne. We're going to start with our first 6-minute rounds. Mr. Barrett's going to kick it off. Go ahead, Mr. Barrett.
Thanks for joining us this morning. Mr. Dufresne, on March the 7th, I wrote you a letter asking you to undertake another investigation into the government's ArriveCan app. So in light of the new information related to the handling and security of Canadians' data, can you provide the committee with an update to your ongoing investigation into ArriveCan?
Thank you, Mr. Barrett. Indeed, following your letter, on March 19th, I announced that I will be investigating allegations of privacy concerns following a complaint against the Canada Border Services Agency related to the development of the ArriveCan mobile app. The investigation will examine contracting practices related to ArriveCan, and more specifically, the measures that were in place to protect personal information during the development of the app, to assess compliance with the Privacy Act, which applies to federal departments and agencies. And so the investigation is ongoing. Under the Privacy Act, I have to maintain confidential the details of that investigation while it is ongoing, but certainly look forward to completing it and to making the findings public once that is done.
Understanding that the Privacy Commissioner has obligations to respect privacy, I will ask you a series of questions, and if you're able to provide us with an update or further information, I'd appreciate it. But first of all, do you have an expected date of completion when we'd be able to see your findings?
I do not. We work to complete them in as timely a manner as possible, but of course we seek answers and submissions and we consider them, but we will be working to complete this as quickly as we can.
Have you been able to obtain all of the documents necessary from the government and contractors that you've sought?
I don't have concerns to raise on that front. There are powers under the Act that would allow me to obtain information if I needed it.
Are you investigating a potential breach of Section 7 of the Privacy Act, which states that personal information under the control of government institution shall not, without consent, without the consent of the individual to whom it relates, be used by the institution except for the purpose for which the information was obtained?
We are examining the contracting practices. We're examining the measures in place to protect the personal information during the development of that app, and we're going to be assessing the compliance with the Privacy Act provisions. And if we see concerns there, we're going to raise those and flag those.
So not able to say specifically which sections of the Act, like whether or not Section 8 of the Privacy Act, which states personal information under the control of a government institution shall not, without the consent of the individual for whom it relates, be disclosed by the institution except in accordance with its section. So Section 7, Section 8, you can't specify which.
My announcement of that investigation has not restricted specific provisions of the Act or otherwise. We said we are looking for compliance with Privacy Act, and if we identify concerns there, we'll raise them.
The Auditor General's report on ArriveCAN made it clear that the record keeping done by the government was really so poor that the Auditor General wasn't able to precisely attribute a cost to ArriveCAN, saying that she thought it was she thought that it was $60 million. Are you finding that to be the case in your efforts? Well,
these would be some of the comments and observation that we would make in the final report of our investigation, as was done by the AG in hers. So this is not something that I would be commenting on at this stage. It would be once the investigation is over.
So I'm interested to know whether or not you've interviewed government officials and contractors and people whose security clearance was unable to be accounted for. So if you can speak to that, I'd appreciate it. But can you take us through what an interview would look like from your office, irrespective of whom you're interviewing?
Well, in our investigation process, we will identify with the departments the issues that we're looking into. We're going to ask them questions. We're going to ask them for documentations, and we're going to look to see if their practices are compliant with the elements in terms of the use, the collection, the disclosure, the safeguards. And as it moves forward, we may have additional questions. We may follow up on that. We prepare a draft report of finding. We share with them. We give them the opportunity to comment. So this will be underway, but these are not elements of information that I would be making public until the investigation has been concluded.
So with an app like ArriveCAN that was mandatory for use for travelers, and for some people, travel is required for their employment, to access medical services, but also just as part of their rights as Canadians to travel freely. The use of the app was mandatory, and the collection of data was mandatory. They had to surrender their personal information. What would the consequences be should you find that CBSA or that the government broke the law, broke the Privacy Act?
Right. Well, one of the areas in the Privacy Act that I would hope to see changed in future modernization of the Act is that I do not currently have the ability to make orders, binding legal orders vis-a-vis a department of the government. So I would make recommendations. I would identify if there are shortcomings. I would identify and make recommendations. So that's what my report would do, assuming that there is a violation.
Okay. Thank you, Mr. Barrett. Mr. Dufresne. Mr. Fisher, 6 minutes. Go ahead.
Thank you very much, Mr. Chair, and thanks, gentlemen, for being here today. I'm interested in, you talked about emerging technologies. Can you maybe highlight what new initiatives and priorities you would be doing, as part of a strategic plan that would grow Canadians' privacy with regards to these emerging technologies in the increasingly digital landscape?
Thank you. So we're doing a lot of things. We issued, we're working very closely with our provincial and territorial partners. This is one of the very elements I'm very proud of in terms of the close collaboration. So we've issued, for instance, a joint resolution on responsible use of AI. setting out our expectations in terms of privacy practices vis-a-vis AI. We've done that with respect to children's privacy, highlighting things like technologies should not be used to nudge children and minors to make privacy harmful decisions. So we're looking at all of those aspects, particular focus on AI, but we're looking as well about how we can use technology ourselves within the OPC to be more efficient. So we've launched an online portal for privacy impact assessment submissions to make that more seamless. We have developed a tool to assess whether certain privacy breaches would give rise to a real risk of significant harm. So again, not to replace the human decision-making, but to provide assistance on that. So we're really looking to see, we don't see technology as something that's prevented by privacy. You can have and you must have innovation and public interest and economic success alongside privacy. So we're really looking at that. Of course, there are always risks with the use of data in powering innovation. And so this is why I've said we do use data to support innovation, but we have to use innovation to protect personal information.
So, first of all, I'm curious as to how Canadians would find out about this, but what can Canadians do proactively on their own to protect themselves? If they're, using these tools that you're talking about is great, but let's assume that...
For instance, with a number of international colleagues in the privacy community around the world, we issued a statement on data scraping, calling on social media companies to take rigorous measures to protect the information on their social media platform, to protect against data scraping, to protect against privacy breaches. Part of that document, we also gave advice to citizens and to Canadians and saying, here's what you could do to protect your own. Don't check your privacy settings on your apps. Make sure that you're aware who you're giving permission to when you're sharing pictures of your kids, the notion of sharenting. Be mindful of the implications. But it's important to reiterate that the primary obligation shouldn't be on individuals to protect themselves. Organizations and departments and laws have to be there, because that's one of the concerns. If we delegate this too much to individuals, they need to feel that there is a system and that those organizations with the tools to do it are taking their responsibility seriously.
I assume you go to school on our allies and what they do in their respective offices. Who's doing really, really well? What types of things are they doing, and are you following the good examples?
Well, we're working very closely with a number of our international counterparts. I'll name a few. The G7 data protection authorities works yearly. Last year in Japan, we issued a joint statement on artificial intelligence from a privacy standpoint. I was very proud of that statement. It's a statement that was endorsed in the Department of Industry, Minister Champagne's statement on voluntary codes for AI. So that collaboration, the sense that my colleagues and I understand the need to have very strong privacy protection, but at the same time very strong economies, very strong ability for organizations to have data across borders. I'll point the UK commissioner, the ICO commissioner. They've done great work on children's privacy. They have a children's code, age-appropriate code, talking about steps that we can take. And I think that this is something that C27 highlights. I was happy to see a recent amendment at Indu Committee recognizing the best interest of the child, which was one of my recommended amendments for this bill. And so I think we're seeing lots of work in this space and lots of awareness to perhaps another example I'll give is the creation of privacy, what we call privacy sandbox, where a commissioner's office will invite industry to come and then test a new process and highlight risks and privacy before this technology is deployed so that the risk could be mitigated, and then you protect privacy and you avoid a complaint on the front end.
Do you get a sense that there are any social media platforms that are better than others at respecting the privacy of Canadians, or are they trying to perhaps look for ways to undermine?
Well, we have ongoing complaints and litigation with some of those social media platforms. So there are clearly some issues that we're looking into. We're in litigation following a complaint decision on Facebook. We have a matter vis-a-vis Google in terms of questions on de-indexing of information. We're looking into our investigation of TikTok. But what I'll say is these social media platforms are attending and participating in terms of the global privacy discussions and meetings, and they are providing their input. They are listening to the comments and the input of the community. But I will continue to reiterate to them through both our promotion and our persuasion tools, but also the compliance tools where necessary.
Do you?
Unfortunately, that's your time,
Thank you.
Mr. Fisher. Monsieur Villemure, pour 6 minutes, s'il vous plaît. Commencez.
Merci beaucoup, Monsieur.
Thank you very much, Mr. Chair. Commissioner, welcome. It's always a pleasure to have you here. I have a few questions that I'll set out from the outset before we get into the heart of the matter. There's someone in Trois-Rivières who's really quite concerned by privacy, and he asked me a question for which I had no answer. So I said I would ask you to get your opinion. They said, if I go on a website, you can continue without accepting, I keep going. But if I refuse, the fact that I even went to a website, personal information, the issue of localization and actually clicking on website, that provides information on people's interests. And that's why we are concerned by these matters. You know, navigation, cookies, the use of this information to create profiles of people. And that is an aspect that is relevant in protecting information. That is why the concern about consenting to cookies and other things, that is an issue, because it allows people to have access to our privacy information. If the person had said, I say no and I leave, is that information still collected? The idea is that it will restrict the use of certain things. Some uses are inevitable, but other information, for instance, can we consent to using this for targeted ads? For instance, one of my concerns in this regard is that often these choices are not choices that are easy to make. The easy choice is to just accept everything, accept all. But refuse all, I would like to see be a much more accessible option. Often you have to click on a few things or go a bit further. People ask some detail. The site will ask you for details. So yes, I think there's work to be done. When you look at when you look at how many partners, etc., you'd have to click 127 times. Listen, if I had to speak to this gentleman, I say he's gone on the site. He did not decide to go any further. He rejected. There's no further information. No, there's no further information collected. But our issue here is the fact that sometimes you don't always know what you're consenting to, or it will prevent you from having access to a service that you otherwise would like to use. This is part of our thought process, and through AI, the capacity for algorithms there is just growing. They're even more able to detect things with less information. There needs to be additional vigilance. So the notion of freedom and choice is called into question. I have another question. My colleague was talking about platforms that do uphold privacy issues. But if you look at the major platforms, which ones are, can we say, rogue? You know, there are a number of people around me that use a whole bunch of things that I've never heard about. Could you say that there are some we should be more vigilant about than others? We recently, we haven't made it public yet, but we've done a review, what we call a data sweep. So what we do is we check with international partners a number of websites on a random basis, and then we look at whether on these websites there may be ways of communicating in a malicious way that will make people renounce some of their privacy rights. And we did it along with our colleagues in the competition field. And that's coming. We don't have the results yet, but that'll give us an opportunity to say, okay, we have some concerns about some of the sites. To date, we have commented on practices that we don't want to see happen, and some targeted issues where a particular organization will be named, then we'll do that. We'll have a complaint process for that, and we have complaints underway. But I'd like to see more sites where there would be privacy by default, by design. I don't like the fact that, as you said, it's easy to accept everything, but not to refuse everything. When they say continue without accepting, is there still information that is collected or nothing at all? The parameters can be set by default. Some are by default that you're agreeing to. And in order to go any further, you have to agree to all. And that's something we're looking at. Our colleagues from the UK have really focused on this. Agree to all. Does that require a legislative change, or is it more a regulatory issue? I think that in C27, there's a lot of focus on the fact that consent has to be something that is easy to understand. It needs to be simpler. There need to be more proactive obligations for these organizations. There will be additional duties from my office to provide some orientation and orders as well. I think it's a step in the right direction. Do you think an order would be upheld? Or is it like the ethics commissioner where the orders are issued, but, well, I'll presume that until proof of the contrary, I will assume that an organization will respect the law. Otherwise, there is recourse before the courts, and that's why it's important to have the power to make orders. Most of these organizations in Canada certainly want or are concerned about their reputation, concerned about their clients, will do the right thing, and will comply to a recommendation. That was the case in the Home Depot file. We made a recommendation, and they kept to it. And that was the right thing to do. The option to have orders and also penalties, financial penalties, is important to have this, not because I want to use them, but it motivates people to make good decisions and prioritize privacy. Whereas if we don't have that, then those decision makers might prioritize other areas where there are financial penalties. Thank you.
Mr. Dufresne.
Thank you, Mr. Dufresne. Mr. Dumur.
Let's go ahead, please.
Thank you very much, Mr. Chair, and I have adequately taken control of my mute button, so I do appreciate that and apologize for earlier disruption. Mr. Dufresne, I always appreciate you appearing before this committee. In so many ways, your work guides the work that we do, not just in the committee, but as parliamentarians. And so I'd like to reference your 2024-2025 departmental plan, where you have survey results on the protection of privacy rights, which I find very concerning. In the 2022-2023 survey, only 39% of respondents felt that businesses respect their privacy rights. That's down 45% in 2020 to 2021. Only 58% of respondents feel that the federal government respects their privacy rights. Again, down from 63% in 2022-2023. Both of these results fall well short of your target goal of 90%. Can you explain why these numbers are so low and what can be done to reverse this downward trend?
Well, I think that those numbers are low. I think this is one of the reasons we've highlighted technology and children in our strategic priorities. I think that there is a sense that technology is more and more intrusive. It's relying more and more on data and on personal information to fuel tools and innovation. And so some of the discussions that we've been having here today in terms of consent to use websites, in terms of what can people do to protect their personal information, I think Canadians feel that they are bombarded by requests for their personal information. And so it's important that the institutions and the systems provide recourses and provide that proactive discipline in organizations to not only protect privacy, but be seen to protect privacy. So I think we are seeing these types of concerns. We are seeing that Canadians want to see more rigorous legal protections about their privacy rights. And this is why we're advocating for a modernized legislation where I would have order-making powers. There would be the possibility of fines. There would be the possibility of real consequences if privacy is not respected. And I think we also need to see more proactive privacy protections that are done at the front end. That's why I've been calling for privacy impact assessments to be a legal obligation, both for departments and for private sector organizations. And so I think that there's work to be done. I think it shows that the Canadians care about their privacy, and that collectively we need to be mindful of this so that Canadians do not feel, as they seem to now, to feel that it can be a trade-off between your personal information and innovation.
And on the topic, so those are some very important points that you've raised. Certainly, when you talk about the impact, the privacy impact assessments, we at this committee dealt with what I consider to be the complete disregard of the mandate of the Treasury Board to provide those. Some departments just completely disregarding privacy impact assessments and only doing it, in fact, after they were caught. But you raised the issue, I think, which is quite important, about safeguarding our youth in this regard. And of course, I'm sure you would perhaps agree that the youth today are not going to websites. They're using platforms, social media platforms. You referenced, I think, an assessment around TikTok. Without getting into the details or preempting the release of your report, can you just provide us a high-level assessment of the ways in which platforms profile, use algorithms to target people based on their interests, and why that would be a problem?
Well, we're focused in some of these investigations, we're focused on the consent. So are you obtaining meaningful consent by Canadians, and are you doing that in an appropriate way with respect to the age? So we have guidance on that in terms of what is appropriate for an adult isn't going to be appropriate for a child, for a minor. So there are different types of circumstances, and C27 recognizes that by protecting minors' information and treating it as sensitive. So that's a positive step, and an additional positive step to recognize the best interest of the child.
A more pointed question, in your opinion, based on your preliminary work on this, do you find some platforms worse than others? For instance, TikTok is constantly brought up, and we're hearing lots of information about that. But how would they compare to, say, an Instagram or X, formerly known as Twitter or Facebook?
Well, what we look for in terms of investigations and reviews is an organization putting commensurate measures to protect the sensitivity of the information of minors and children. Are they aware of the likelihood of their users? So we're investigating TikTok, and we announced that we were going to be focusing particularly on children's use, because this is a big part of the clientele of that website.
Is that because you don't think Instagram and Facebook and X do the same, or that they do it in different ways? Help me understand that.
Well, we're investigating TikTok right now, so this is the one where we will have some findings to make. We have made a general statement about for all social medias in terms of protecting the rights of children. With my provincial territorial counterparts, we cautioned against nudging techniques that would encourage children to give more personal information than they need to. We've called for a treatment of children's personal information to be different, to have a greater right to delete information. So I won't make a specific comment about a specific website if we haven't investigated it particularly on that issue, but generally we are calling on all of those platforms to be mindful of those elements. And again, I think C27 will bring greater tools in this respect with this heightened protection. And I've made it one of my priorities, so we're going to continue the education work, but also targeted compliance as needed to protect children whichever platform would be at issue.
Okay, thank you.
Thank you.
Thank you, Mr. Green, Mr. Dufresne. Mr. Kirk, I have you up. We're going to start our second rounds for 5 minutes. Go ahead, sir.
Thanks very much, Chair, and thanks. Thanks, Commissioner. I'm curious, Commissioner, are you aware of the privilege debate that took place in Parliament last night and this morning regarding 18 members of a parliamentary association that with an attempted hack of personal information?
I am not. No, I haven't been briefed on that yet, unfortunately.
Okay, so it's a very quickly developing situation, but we learned only a couple of months ago, because of an unsealed report from the Department of Justice compiled by the FBI in the United States, that in January of 2021, there was an attempt by a hostile foreign state actor connected with the communist dictatorship in Beijing that had attempted to infiltrate 18 parliamentarians' personal email accounts. I'm wondering, and I know you haven't had a chance to get into the debate that took place in Parliament, and I was hopeful, and certainly I've been at committee here, so we haven't been called to a vote. So I think that's a good sign that it passed unanimously to send that to Proc. But I'm wondering if you could maybe share some thoughts with this committee about how important that is, and if I could encourage you, not just when it comes to the protection of private information, when it comes to MPs being able to do their jobs, because obviously that's one part of it, but what I brought up in my speech last night was how important it is to ensure that Canadians feel protected and that appropriate responses are brought forward when there's attempts to use private information for nefarious purposes, whether that be diaspora communities that may be at odds with a government that they have a connection to. I'm wondering if you could provide any comments on that and share some thoughts with this committee.
Sure. Well, what this highlights, and I've issued a declaration last December with the UN Special Rapporteur on privacy and human rights, and I highlighted the link between the protection of privacy and other fundamental rights, and that includes democratic rights. And so protecting privacy, whether it's the privacy of members of Parliament, whether it's the privacy of voters and citizens, we can see that there overlaps with other sectors. That's why it's so important to protect privacy for its own sake, but also because it supports and promotes other fundamental rights. And so that's an issue that's raised in this instance. I will certainly be interested to see where the parliamentary privilege question is a question for the House, of course, but certainly will be mindful and being briefed on it. There is proposed modification to the Elections Act vis-a-vis privacy obligations for political parties. So that's another example where you have some intersectionality with my office has a role to play, but there are other regulators, Canada Elections CEO. And so this is an area where I work very closely with other regulators where there are areas of overlap. And so we'll be following up.
So is informing, whether it's parliamentarians in this case or whether it be informing the public. I know it was interesting as the debate was taking place last night, Premier Eby out of British Columbia had announced, and I happened to see the statement on Twitter, and of course it provided a link to a government of BC website, but is informing those affected and generally the public of what's going on a part of that process of making sure that privacy can be safeguarded?
If we're talking about privacy breaches generally in the private sector or public sector, one of the elements is that the organization would have to notify my office and would have to notify the affected individuals as early as possible. So that's part of the mechanisms to provide that information, and then mechanisms to take steps to protect and prevent and address it. So we have complaints underway with respect to privacy breaches, for instance, with the government's Geolocation Services, BGIS. We've launched an investigation vis-a-vis the Global Affairs privacy breach. So privacy breaches are something that we are concerned about. They're happening more and more, and we have a role to play in that.
Okay. Thank you, Commissioner, and certainly I'd value if you have any. I'm basically out of time, but if there's any further feedback that you could provide this committee, and hopefully if you have a chance to send as Proc, hopefully we'll be seized with this in the near future. I'd certainly encourage you to share your feelings and feedback there. Thank you.
Thank you.
Okay, yeah, thank you, Mr. Kirk. We're going to go to Mr. Baines next for 5 minutes. Go ahead, sir.
Thank you, Mr. Chair, and of course, thank you, Mr. Dufresne, for joining us again today. I'm curious about understanding a little bit more about how big is your team that you're working with? What resources do you have, and is this allowing you to be more proactive in engaging strategic priorities, or where are you at with your office and your team?
Thank you. So we have roughly 215 employees at the OPC, and we have proposed budget funding for my office in 2024-2025, main estimates of 34 million. We have had an increase of 4.5 million in the previous year, attributable half of that to collective bargaining increases. So that's not really increasing our budget or our ability to do our work. It's just maintaining it. And we've had temporary funding as part of budget 2023 of 2.4 million for that year to help us address backlog and privacy breaches. We need increases in our budgets on a permanent basis. This additional funding is useful and very important, but it will come to an end. And the challenges will not come to an end. We are seeing more privacy breaches. We are seeing them on a larger scale. We are seeing them more complex, and technology is making it more challenging. So there's a need for more permanent funding on that. And on specifically the point of more proactive and promotion work, we will also need additional resources in this space, particularly with if C27 is adopted. C27 would bring new responsibilities to my office, both from an enforcement standpoint with order-making powers, but also, as importantly, more guidance opportunities to help organizations and small, medium enterprises to know what their obligations are, to provide clarity on this. Industry needs as much certainty as possible to do their work and to know what the expectations are. There are very interesting provisions in C27 that would allow the preparation of codes of practices and certification program. This is something that businesses around the world have been asking for to give them more certainty. And I would be playing a role in approving them and providing some more legal certainty. So there are lots of things that we could be doing. The resources limits that. Of course, public resources have to be used judiciously and cautiously. So we're looking at that. We've made some requests. We're going to continue to do that in a fiscally prudent manner.
Okay, thank you. So it's clear that your obligations are continuing to change, and your scope is broadening. So more as this technological advances occur, you have to continue to keep growing from there. So I understand that. Can you expand on the sandbox example you gave, and how do you, and maybe even the data sweep, what is the criteria you use?
So in terms of the sandboxes, organizations, we're not currently resourced to offer this, but my international counterparts are, and they are doing it with business. And so they will say, you can come over and you can test this new technology in a safe space where the regulator can provide input, can provide risks. So we're able to provide proactive guidance and to be consulted, and we have services for that, but not to the same extent of sandbox. This is something I'd like to be able to do. I think it would be good for Canadians, and it would be good for industry. So we've identified that we would need ongoing annual funding increase of about 25 million for C27 to optimally provide those services based on those new authorities. In terms of the sweep that you made reference to with our partners, we look at various numbers of website and see, and I don't have the randomized formula that was used by the team, but the goal is to say we're going to do some spot checks and see are there trends, are there concerns, are we seeing some websites that are using what we call deceptive practices or dark patterns, which are communication tools that will lead people into making bad decisions and will sometimes trick them.
I just want to, just on that piece there, you talked about nudging techniques. Can you give some examples of that, and before I run out of time, I'm curious to also, if you can add on, if like, should we be having an educational campaign across Canada, to ensure people know what to avoid, what kind of nudging techniques there are?
So, Mr. Baines, you are out of time, but Mr. Dufresne, if you can answer that question.
Yes,
quickly,
very
please.
quickly. A nudging technique is basically you're making it very easy to make one choice and you're making it very hard to make another choice. So when you're making it very easy to make a bad choice, you're nudging towards that bad choice.
Okay. Thank you, sir. Monsieur Villemure, 2 minutes et demi.
Président, je vais encore profiter de votre présence.
I will continue along in the same vein as my earlier round of questions. When someone told me the other day that when they agreed to the strictly necessary cookies, who determined that it is strictly necessary? Is it the company or is it a standard? That's the opinion of the company, the business. But in the Act, there are obligations that state that businesses should not be collecting further information than what is necessary for their purposes. But the determination is made by that organization. Inaudible? Answer, it could be challenged. Someone could say, well, was it really necessary? And then there are processes in place, including my office's work, to address that. When it comes to privacy, are there any particular concerns? You're referring to what specifically? The apps that allow for inaudible to the interpreter. Answer. That was mentioned in my office. There will be legislative processes to make the banking system more open, in other words, more sharing of information for consumers, but also to fight against money laundering, etc. So you were talking about one-step banking. In one case, it would be regulated by the authorities, the banking authorities. On the other hand, it would be the anti-money laundering authorities. But in both cases, I will be involved. I will be consulted. I expect that. And in the case of money laundering, there is an expectation in the bill that there will be regulations for me to approve codes of practice that will be doing that. So I think these are certainly developments that will foster more developments and encourage people to communicate, to have further banking services, but communicating the importance of privacy first and foremost. And I will raise this issue so that we make sure we don't have innovation to the detriment of privacy. So even despite this innovation, which sounds good, there still be a focus on privacy as a fundamental right. I will continue to ensure with the legislative powers that I have that that is the case, and in the context of new bills, I will provide my opinion to the relevant committee if it has to be enhanced, if this process has to be enhanced. But I will certainly be very active in raising these issues, as I've done in other areas, like in the area of cyber security or national security. I've said it many times. This is not a zero-sum game. We don't have to say, oh, you can't have innovation without sacrificing privacy. But it requires work. It requires consultations. And a tangible example of this, last year with my colleagues from the Competition Bureau and the CRTC, we created a forum for regulatory organizations in the digital space to say we want to work together. We don't want there to be these zero-sum game concepts. And we've just renewed it for a second year. I'll be presiding this forum for the second year, and we'll be looking for deliverables.
Yeah, Mr. Green, 2.5 minutes. Go ahead.
Thank you very much. I'm going to put two questions relatively quickly to you, sir. You reported that 55% of complaints received by your office are responded to within the service standards, but that is still below your target of 75%. Can you explain what steps you are taking to reach the 75% target?
Right. So we are, we've obtained additional funding, and that's helped. We are looking at our processes. We have done an assessment to see can we find efficiencies? Can we streamline? Can we have some more early resolution of complaints? We're really looking at all of those aspects, and this is the strategic priority number one in my strategic plan, talking about optimizing the OPC.
Is the funding
itself
adequate, sir?
Well, the funding is not adequate. It's not permanent. So we have had temporary funding, and that has helped greatly. But we need permanent funding because those complaints are permanent, and those breaches are permanent, and they are increasing. And so this is something that I hope.
On March 7th, 2023, the Information Commissioner of Canada appeared before our committee, and she had some feedback on the way in which you're funded. On the topic of funding, I strongly believe that a model that gives the Minister of Finance and the Prime Minister the power to limit the required funding agents of Parliament is contrary to our oversight role. As agents of Parliament, we report directly to Parliament rather than to a cabinet or a particular ministry. Frankly, the manner in which we're funded should reflect this independence. Do you agree with that statement?
I do. I think as agents of Parliament, we report to you. We don't report to the executive branch. And in fact, we investigate complaints against the executive branch. In my case, there may be a difference vis-a-vis the private sector mandate that I have. I have both public sector and private sector. So maybe less of a concern vis-a-vis the investigation of the private sector, but vis-a-vis the investigation of the public sector, there is that appearance of concern.
Straightforward. Do you have any recommendations on how to make the process by which funding is provided to the officers of Parliament entirely independent of the government?
Well, there was a process in the past where the requests were reviewed by a committee of parliamentarians. I think it was chaired by the Speaker's office, and you had representative of all parties, and then it went forward to Treasury Board. So it wasn't fully independent, but it certainly provided greater oversight, where there's the example of the Parliamentary Budget Officer or Elections Canada. So have less of a approval by the Treasury Board and the Executive and more of an approval by the Speakers or the Houses. So they're tools. I think that the key point is more legislative involvement.
Okay, thank you,
Thank
Mr.
you.
Green. Mr. Dufresne, we're going to go 4 and 4. Mr. Brock, followed by Ms. Khalid. We do have some votes we need, so I need to leave a little time for that. Go ahead, Mr. Brock, for 4 minutes.
Thank you, Chair, and thank you, gentlemen, for your attendance. Commissioner, my questions will be directed towards you for the 4 minutes that I have. Is it accurate, sir, that apart from my colleague, Mr. Barrett, he is the only parliamentarian to launch a particular complaint and a request for your office to investigate the circumstances behind the Arrive scam issue?
The current complaint. The current complaint was in response to Mr. Barrett's.
Is the only parliamentarian?
My team can correct me if I'm wrong, but my understanding is that's the case.
Okay. Have you received anonymous complaints from any other source in relation to the Arrive scam debacle?
I don't have that information, and I'm not sure that that's necessarily information that I would be making public if it has been an anonymous situation. So I'm not sure how to respond to that.
Sure. I'll be more specific. Have you received any complaints, any areas of concern raised by any current or former CBSA officials or employees?
Again, these are not, the Privacy Act provides significant confidentiality obligations on me on that.
Okay, I anticipated that response. I thought I'd ask it though. Following up on a point that I'm not sure I was clear on in terms of or an inability on your part to provide meaningful consequences should there be a violation of your act. Did I get that correct?
You did. I do not currently have the ability to issue binding orders under the Privacy Act.
Okay. What about monetary penalties?
Same. There's no monetary penalties.
Okay. And this has been an issue since the Act was amended and created. Is that correct?
That's correct, and that's a concern both on the private sector side and on the public sector side.
And you've made several recommendations along those lines in your current role, and I'm sure your predecessors have probably voiced very similar concerns to committee members, and literally since 2015 there has been no appetite by the Justin Trudeau government to provide any meaningful consequences to these violations. Is that correct?
Well, Bill C-27 was introduced by the government, and it would provide me with the ability to issue orders, and it would provide for the ability for fines to be issued. That's on the private sector side. In terms of the public sector, there's no bill to modernize it. Currently, the Department of Justice has done a consultation paper where that was a recommendation in terms of greater compliance mechanism, and I certainly encourage that from moving forward.
Sure. And when was that recommendation made by the DOJ?
The recommendation was made in 2021, and then since they've been consulting to get, in particular, more of an Indigenous perspective on this. My office, under my predecessor, supported this, of course, and as do I.
Okay. Quickly, one quick question on the Arrive scam issue. There is allegations, very strong allegations, that a vice president of the CBSA by the name of Min Doan had intentionally deleted 4 years' worth of relevant emails. Emails that would have been very helpful to the Auditor General when she conducted her review. Emails that would have been helpful for the internal investigator who is still investigating the actions of several players. Do you think this would have been helpful for you as well if you had access to that? And if so, sir, what do you say in terms of your position as a commissioner in relation to those allegations?
Very quick response, please.
Well, if I were to make any comments on that, it would be at the conclusion of an investigation if we had seen concerns. So it's not something that I would comment on at this stage.
Ms. Khalid, for 4 minutes, go ahead.
Thank you very much, Chair, and thank you to our witnesses for being here today. Really appreciate always your input. Just want to pick up on a point raised by my colleague, Mr. Green, with respect to balance of powers and something that you had said as well. Is it possible for there to be a complete separation between what your office does and what the government and the interaction between the two?
Well, we work very closely. Agents of Parliament, it's not a perfect, complete separation. We're proposed by the executive branch, but we're approved by the houses. So there is certainly independence, but we're working as part of the public service, and we are applying a number of the procedures. And we also have to work very closely with the Treasury Board, which is providing guidance on Privacy Act compliance. And my approach is, you've heard me recommend for strong compliance powers, and I believe this is necessary. But I'm also a firm believer in collaboration and prevention. So I do work very closely with the departments to inform them of privacy and encourage them to raise issues in advance so that we can prevent them.
So just expanding on that, then, how do you work with stakeholders to navigate through the changing needs of what privacy concerns Canadians have right now?
Well, we do a lot of outreach with all sectors, so civil society. I've had a very interesting discussion with children, youth parliamentarians, very interested about their challenge and how they see privacy issues and how they interact with their schools. And I want to see privacy as part of a mandatory curriculum. It's not exclusive, certainly not exclusive federal jurisdiction. I'm going to work with my provincial colleagues on that. Work very closely with industry. I receive complaints about industry, of course, but it's important for me to understand what are their realities. We want laws and rules that make sense, protect Canadians' fundamental right to privacy, but also has to work for industry. I want Canada to be competitive and innovative. I've said my 3 priorities, my vision for privacy is a fundamental right, but privacy supporting innovation and supporting the public interest and generating trust. So it's important that I understand those realities, and it's important that they understand my preoccupation. So it's a very helpful dialogue where they will say, here are the challenges we face on the ground, and I will say to them, here's what I'm hearing from Canadians where they feel that their privacy is not being protected. And so that dialogue continues, and then if issues are not resolved, there are ways through compliance. But even through compliance, I think in some cases, we may find that there is a violation, make a recommendation, the organization learns it, they speak to their counterparts, and then they implement the good practice.
So I know that there's been conversations about digital ID as part of trying to circumvent a lot of these issues that you've talked about. What is your viewpoint on that? Do you think that that is something necessary, and how does that work with our privacy laws?
Well, this is an example where I've had strong collaboration with my provincial territorial counterparts in the Privacy Commission, and in October, not this October, but the year before, we actually issued a joint statement on digital ID from a privacy perspective. And so we flagged that this is something that can make it easier for Canadians to interact with their government and so on. but it has to be done, if it is to be done, in a privacy protective manner. And we gave a number of advice on that. It should preserve anonymity. It should not be a central repository and so on. So there's a number of comments. We didn't say you can't have it. We said this is something that could certainly be useful. Make sure you do it in a privacy protective way, and we gave some clear advice on how to do that.
And would a digital ID in the hands of a private company pose significant risks to Canadians?
Well, all aspects of obtaining digital identification or biometric information about anyone, whether from the public sector or private sector, is an area that people have to be mindful of. We currently have draft guidance on use of biometric information, one for private sector, one for public sector. We've received good feedback from industry and from Canadians on that. We're working to finalize that. So certainly any type of innovation, digital or otherwise, it brings a lot of benefits, or it can. We need to make sure it's not done at the expense of privacy, and there are ways of doing it.
Thank you, Ms. Khalid. Thank you, Mr. Dufresne. Mr. Dufresne, I do appreciate you being here on behalf of the committee today. Thank you for the work that you're doing, the important work that you're doing on behalf of Canadians. Mr. Ruth, thank you for being here in support as well. So I'm going to move to the main estimates right now. I'm going to ask the committee whether we have unanimous consent to adopt all votes on the main estimates 2024-2025 referred to the committee in one vote. Do we have consent to do that? Yes. Okay. Thank you, Mr. Green. Monsieur Villemure. Shall vote 1 under the Office of the Commissioner of Lobbying, vote 1 under the Office of the Conflict of Interest and Ethics Commissioner, vote 1 under the Office of the Senate Ethics Officer, votes 1 and 5 under Offices of the Information and Privacy Commissioners of Canada carry? On division. On division? Thank you. Shall I report the main estimates 2024-2025 to the House? On division. Okay, thank you. We're going to suspend for a few minutes while we set up the next panel. So the meeting is suspended. Thank you again, Mr. Dufresne. Unfortunately, we've had some technical issues that have occurred, mostly with the headsets. So unfortunately, all with the headsets, so unfortunately, the witnesses for the second hour are not available to the committee today. So what we're going to do is I'm going to ask the clerk if we can see if we can re-invite the witnesses to another time. And it's just unfortunate that we're in this circumstance, but the nature of hybrid meetings, unfortunately. So, go ahead.
Can you confirm that the witnesses were all sent the correct headsets? Because it's just important to note that we approve budgets for these studies. We incur an expense to send the headsets. We incur an expense for the physical headset, and so while it's regrettable, we appreciate the acceptance of invitations by witnesses. There are standards that we have. This is a workplace, and we have to respect the health and safety of everyone in this workplace, and that includes using the proper equipment. And so I just want to make sure that, and I'm sure it's always been the case before, that we've sent the headset. So life happens. I appreciate that, and so the inconvenience is unfortunate. But the error, just to confirm, isn't on the part of this committee or the House.
I'm going to defer to the clerk to answer that question, Mr. Barrett. My understanding is that the headsets had been properly sent. There were some circumstances that I'm not going to get into for the sake of the witnesses where they weren't available to them. But, Madam Clerk, if you want to talk about that.
Yes, absolutely. So in answer to Mr. Barrett, and thank you for the question, it is a good question. Indeed, the two witnesses who were supposed to appear on May 2nd were sent a headset for the May 2nd appearance. The two of them are busy people and traveling the world, and so they were somewhere in Canada at the time, but they are now currently traveling the world. And so they were informed that in order to appear, they do have to have the proper headset. But somewhere with jet lag and the step from a city to another and another, the witnesses, one of them specified that he had the headset and he left it somewhere on the way. As per Mr. Giguère, he was currently in the United States. A headset was sent over to him. The headset yesterday, we saw that it was still in the United States in the facility, so we followed up, and he got himself one of the approved headsets, which we can reimburse. And the tests were all done. However, it seems sometimes it happens that for some reasons that we do not understand, the sound is nonetheless not working. But if the witnesses forget the headset somewhere, but it was provided and they were informed.
Understood. Thanks.
Okay, thank you, Mr. Barrett. It is unfortunate because obviously a lot of resources go into ensuring that these meetings properly function, but it's where we're at. So, Ms. Khalid, go ahead.
Thank you, Chair. And given that proper notice has been given, I move that, given the comments of the Leader of the Opposition last week, in which he suggested he would use the notwithstanding clause if given the chance, and previous statements that the Conservative Party of Canada would require a digital ID to access content on the Internet, that the committee report to the House that the committee, A, recognizes the importance of the Canadian Charter of Rights and Freedoms to protect the rights of all Canadians, including the right to privacy, and B, opposes the federal parliament's use of the notwithstanding clause in all instances. Chair, I'll check with you to see if everything is in order before I speak to the motion.
Yeah, I've thought about this motion over the last couple of days, Ms. Khalid. I'm going to rule it inadmissible for several reasons, not the least of which is there's a couple of references to the notwithstanding clause in the Canadian Charter of Rights, which I believe falls under the purview of the Justice Committee. And the second reason is what I deem to be a hypothetical assertion in relation to the Conservative Party leader's digital ID. So I rule the motion inadmissible outside the scope and mandate of the committee, Ms. Khalid.
Chair, I would like to challenge your ruling because I have seen other, a lot more loosely worded motions move forward in this committee. This is a significant issue with respect to privacy and with respect to the rights that are enumerated within our charter, and I think our committee has an obligation to pursue this.
Okay, so Ms. Khalid would like to challenge the ruling of the chair. I'm going to go to the clerk for a vote on that. Go ahead, Madam Clerk.
So the vote is a challenge on the ruling of the chair. The question is, shall the decision of the chair sustain? Mr. Baines.
No. No.
No.
Ms. Damoff.
No.
Mr. Fisher.
No.
Mr. Hauswater.
No.
Ms. Khalid.
No.
Mr. Barrett.
Yes.
Mr. Brock.
Yes.
Mr. Kurek.
Yes.
Monsieur Villemur.
No.
Mr. Green.
No.
Yeas, nays, 5 nays. Whatever. It is in the book. Sorry about that. So it is nays 6, yeas. Sorry, I'm losing my track. Sorry about that.
Three.
Yeas 3.
Okay. So the ruling is not, so the ruling is not sustained.
Terrible. Sorry about that. This is a terrible vote on my side. My PDF was not ready. So it is nays 7 and yeas 3. There we go.
Yep.
So
So the decision is nay. So the motion is moved. Do you want to?
I'd like to speak.
Go ahead, Ms. Khalid, and then we're going to go to Mr. Kurek.
Thank you very much, Mr. Chair. I really do appreciate this opportunity. And, you know, over the past couple of weeks, I've been quite alarmed. I grew up in this country. I know I was not born here. I came here and got to realize the importance of our Charter of Rights and Freedoms because my front door neighbors don't look like my side door neighbors. We don't practice the same religions. We wear different shells and we have different ideologies, and yet we are still one of the most peaceful countries in the world. And so when I see rhetoric around what the implications of the Charter of Rights and Freedoms and what our Constitution is in the future, it really makes me very alarmed in the context of what social media impacts digital IDs, for example, the proposition thereof, in terms of what political parties and the leader of the opposition is saying. It really alarms me, and I think that it is important for our committee to have a commitment in Parliament as to how we're going to move forward on making sure that our Charter of Rights and Freedoms, that our Constitution is maintained, and that we continue to abide by that. Now, I'll quote, there have been articles that have stated that, quoting the leader of the opposition, that he will pass criminal laws using whatever means. And he says, we will make them constitutional using whatever tools in the Constitution allows. I think you know exactly what I mean. Now, from my perspective, given that this is a person who was part of a team that tried to pass the Barbaric Cultural Practices Act, a snitch line on people like myself, my mother wears a hijab, for example, and given that how diverse our neighbors are, it really alarms me as to where this is coming from. It also alarms me, Chair, when we talk about a woman's right to choose and seeing conservative antics in the House right now questioning can a woman choose what she does with her body and whether we're going to criminalize that using whatever tools necessary to control what a woman's body is. The implications are very, very severe for me. And, you know, he continues to say, even if my proposals don't meet the constitutional standards, I'll make them constitutional using whatever tools. Chair, that is very, very alarming. And when you pair that with concerns of privacy within our social media and the framework that we have right now, that already we are really testing the limits of how we make sure that we protect the rights of individual Canadians in our country, including the right to privacy, including minority rights, whether it be LGBT, whether it be different religious groups, whether it be a woman's right to choose. It is really, really alarming, and I think that it is incumbent on our committee to be able to pass this motion and get that through the House. Now, in Ethics Committee, we've studied the collection of data, et cetera, and I'm talking specifically about the right to privacy piece, and specifically on the digital ID, on collecting information from Canadians. Now, the leader of the opposition is proposing to leave data, sensitive data of Canadians in the hands of a company like Pornhub, for example. And that is, again, a slippery slope as to how far that goes. How are we maintaining and protecting that data? Should that data be there? When we talk about the right to privacy, we really need to ensure that we are maintaining that right to privacy within industry and within our government, and how Canadians' rights are protected. I mean, we've seen what happened with Ashley Madison, with a hack, for example. We've seen MPs with top secret security clearance being blackmailed over their use of the internet and the photos that they have circulated. So, Chair, I will say and reiterate the importance of ensuring that we have the ability as a federal government to ensure that our Constitution is maintained, it is protected. It is important for all parliamentarians. Chair, when somebody tells you something, you believe them. And we have been effectively told that our Constitution is a workaround for the Leader of the Opposition, and we need to ensure that we protect the rights of Canadians and our Constitution in how we operate here as parliamentarians. And I'm hoping that we can pass this motion very quickly through you, Chair. Thank you.
Thank you, Ms. Khalid. I've got Mr. Couric, Mr. Barrett, Mr. Brock, and then Mr. Housefather after that. Go ahead, Mr. Couric.
Thanks very much, Chair. And it is really interesting to hear the Liberals talk. And I'd like to address two things, if I could, Chair. First is what is an underhanded swipe at a bill that passed the House of Commons with a plurality of support here only a number of months ago, and that is Bill S210. And what's interesting is there was some support from all parties, but functionally, what this motion and Ms. Khalid seems to be doing is to somehow stand up for the very companies that she just stated she didn't trust. She wants to stand up and allow them to distribute violent, pornographic material to minors. That is astounding, shocking, and quite frankly, Chair, absolutely disgusting. When I've taken great interest in Bill S210 because of how the detrimental effects, Chair, that a young person being exposed to violent, explicit material can have in a young person's mental health, in their ability to form productive relationships, and for the Liberal Party to be doing the bidding of a company like MindGeek that runs sites like Pornhub, that is willfully, and the Privacy Commissioner referenced earlier today how they've just completed a study on some of the privacy concerns with that. It is astounding that they would be opposed to this, something that united all senators. And Chair, you've heard me talk, I'm sure at length, about some of the frustrations I have with the other place, as we refer to it. But when S210 passed unanimously through the Senate, and I believe that there was more than 40 different options presented for a site that hosts explicit material to be able to verify someone's age. Yet the Liberals don't care about the facts. They want to play politics and suggest that this is about digital ID. Mr. Chair, I tell you, this is a divide and distract at its best. They are doing the bidding of some of the worst corporate players in history. In history, as has been revealed by the good work of Canadian parliamentarians, as was an expose in the New York Times that was describing this, and those Liberal members would carry water for that? Absolutely unbelievable. So there's a lot more that certainly I could say about that, but it is obvious that they either haven't read S210, haven't read the bill, haven't cared enough about actually doing the research into what's being proposed and how it can actually protect young people, or they are intentionally trying to divide and distract from on an agenda that I won't even pretend to know what that involves, because it is certainly beyond the pale. But Mr. Chair, I would like to, if I could, share just briefly about some of the assertions related to the Charter. And again, this is what I can suggest is nothing more than an attempt to divide and distract Canadians. What the Leader of the Opposition has made very clear is that when it comes to the most heinous criminals in our history, the Quebec City mosque shooter as an example, the Leader of the Opposition was very clear that the justice reforms that he is proposing would make sure that heinous criminals like that, the only way they leave prison is in a box. And I know my colleague from Leeds, Grenville, Thousand Islands said similarly, and that was a comment. But Chair, the Liberals don't seem to care about that. They care more about trying to, I don't know, score cheap political points or something to divide and distract, as opposed to have meaningful discussions around justice reform. And certainly when it comes to the notwithstanding clause, it's as if the Liberals forget that Section 33 is a part of the Charter of Rights and Freedoms. Now, are they deceiving, misleading Canadians on that? And it goes back to the very fundamental basics of the Westminster democratic system, and that is the fact that Parliament is the supreme lawmaking authority of the land. So I would hope that their intentions are not nefarious, but it certainly leads, and I'll let Canadians be the judge of that. Because when it comes to the criminal justice reforms that are being contemplated and suggested by the Leader of the Opposition, it's been very, very clear. And freedom, Chair, is a sword that slices both directions, for those you agree with and those you disagree with. And for members of the Liberal Party to suggest somehow that they stand up for the Charter when it is literally, and this is not the figurative use of the word literally, they are literally the only government in Canadian history to willfully suspend charter rights against Canadians. They did that, and it was found that it was done illegally. Chair, it is unbelievable that they would use these sorts of tactics, that they would gaslight, that they would, I don't even know that there's words strong enough that would be parliamentary to describe what the Liberals are doing on this. So if they want to discuss the use of the notwithstanding clause, I'm happy to do so, Chair, because there is a very clear case to be made that the most heinous criminals in Canadian history, they deserve to be behind bars. And I challenge constituents or the members of the Liberal Party to go and tell their constituents that those individuals should walk free on the Canadian streets. I challenge them to go to their constituents again when it comes to the issue that I first talked about, when it comes to the suggestion that somehow some of the worst corporate players, some of which have even moved their operations out of Canada, that they should somehow have a free pass to distribute explicit material to minors, and the devastating impact that that has on the mental health of our youth. Chair, it is seeing the worst of what so many people see when they think politicians. So, Chair, I certainly have a lot more that I could say on this, whether it's the constitutionality of what we've been talking about, how the hypocrisy of members of the Liberal Party, how it is astounding that they are trying to divide and distract in this way to somehow score some cheap political points because they're desperate, maybe seeing the fact that it's actually Canadians that get to make choices in elections. That is something that no parliamentarian should ever take for granted. But, Chair, I would move an amendment if I could. I would, because I think that there is a valid point to be made. So here's an opportunity. Let's take the political spin out of what the Liberals are trying to gaslight Canadians with, and let's move to a point where we can have a real discussion about what it means to actually protect the rights and freedoms of Canadians. Therefore, Mr. Chair, I would move that the first sentence up to that the committee report to the House, that the committee, so strike the first part of that sentence, and keep point A, and delete point B. And Chair, we'll make sure that the clerk gets a copy of that momentarily.
Okay, just do me a favor. Just repeat what you had said there, Mr. Couric, on your amendment, please, if you don't mind.
So that strike the first part of the first paragraph up to and keep that the committee report to the House, that the committee, and then keep point A, bullet A, and remove point B.
Okay, so the way I'm reading it then is that the committee recognize the importance of the Canadian Charter of Rights and Freedoms to protect the rights of all Canadians, including the right to privacy. Is that what you're proposing?
So yes, I accept that the committee report to the House,
Okay.
that the committee,
Okay.
and then point A, as you described.
Okay. So the amendment's on the floor. I'm ruling it in order. Yes.
Point of order.
Go ahead. Point of order.
Mr. Chair, this whole resolution is about the notwithstanding clause. This amendment removes all references to the notwithstanding clause. It goes against the principle of the motion, the original motion. It should not be receivable. And if the chair is ruling it receivable, I challenge the chair.
Okay. Hang on a sec. So after reviewing the amendment, Mr. Housefather, I am going to rule it in order. I'll accept the challenge if that's what you like. Go ahead. Madam Clerk, we have a challenge of my ruling on the amendment. Please call the vote.
So again, this is a challenge on the ruling of the chair, and the question again is, shall the decision of the chair sustain? Mr. Baines.
No.
Ms. Damoff.
No.
Mr. Fisher.
No.
Mr. Hosfather.
No.
Ms. Khalid.
No.
Mr. Barrett.
Yes.
Mr. Brock.
Yes.
Mr. Carrick.
Yes.
Monsieur Villemur.
Oui.
Mr. Green.
No.
Yeas 4, nays 6.
So the decision is not sustained. So the vote's in. The decision is not sustained. I'm going to continue on the motion. Mr. Kirk, I see your hand. I'm going to get back to you. Or
On the list.
I'll put you on the list. I have Mr. Barrett is next. Go ahead, Mr. Barrett.
Yeah, thanks very much, Chair. With respect to the comments from the Leader of the Opposition with using the Section 33, the notwithstanding clause, I think it's important to note that Section 33 is Section 33 of the Charter. So it's of course legal. It's of course part of the Charter for a reason, and once used, the laws in question are of course constitutional. When we're talking about the rationale for using the notwithstanding clause, look, when you have someone like my colleague Mr. Kirk pointed out, like the Quebec City mosque shooter, who stormed a place of worship, who murdered in cold blood 6 innocent worshippers in a place where they must have felt safe. We have to feel safe when we go to our places of worship. And the violation of that sanctity can't be overstated. And the heinous disregard for the lives of the victims in that terrible event. And I'm not going to use the name of the shooter because they don't deserve the notoriety that they were seeking. What they deserve is to spend the rest of their natural life in maximum security prison. And what we've seen is that's not the reality that that individual is going to have to live with. So what are the other options? Well, they'll go to medium security. And then they'll end up with a security override. And they'll be in minimum security. And they'll be living in a townhouse with other offenders on a street where there's no walls and no barbed wire.
Point of order, Chair. Minimum security is not a townhouse in communities. I mean, we could at least stick to the facts here.
Subject to debate, Ms. Damoff. Go ahead, Mr. Barrett.
Well, Chair, I would just say to Ms. Damoff, I'd invite her to go to Pittsburgh Institution just outside of my riding, where the minimum security inmates live in townhouses. They have a shared kitchen. There's a single door handle lock on the door, no alarms on the windows. They wear their jeans and T-shirts on the weekends and walk of their own volition down to the creek and go, or down to the lake and go fishing. There's no fence to keep them in, and there's a lot more of them than there are guards. And do you know how I know that? I was there 2 weeks ago, and I walked in. There was no fence, and there's no fence and there's nothing to keep them in. And the individuals who are in there, multiple security overrides have been used. They're not minimum security offenders. There's just no room for them. So we've got people who should be serving sentences in more restrictive conditions, but they're living in a townhouse. The pork chops thawing on the counter when I went inside. Opened the fridge, and it was jammed full of food, fresh fruit, fresh vegetables. One of the residents of the townhome was sitting watching TV, welcomed me in. And his compatriots were not working for the day. They were sitting on the step, just enjoying the sun on their face. And that's what we can expect when we don't have a framework in place where the most heinous of crimes, like the individual that I referenced before, who perpetrated a heinous crime, ought not to leave maximum security, save for in a pine box. That's what we're talking about when we talk about the use of the notwithstanding clause. And the Leader of the Opposition has been explicit about that. And if anyone missed that, I'm reiterating it right now. That's the type of criminal justice. That's exactly the criminal justice use that is required. And we know that minimum security escapees, people who have been inmates who have been in max and had security overrides down to medium and down to minimum, have just walked off site and perpetrated more heinous offenses, made more victims of the people who live in the communities around there. That's not our expectation. So we had a point of order moved by the former parliamentary secretary to the Minister of Public Safety, former, now in a different parliamentary secretary portfolio, right? And it is a matter of public record that minimum security inmates have been able to walk off. It's also, I have verified it with my own eyes in the last couple of weeks, the conditions that these inmates live in. And I can tell you I was surprised that I live so close, and I know people live in my community who work at this institution, and I had no idea that these were the conditions that exist at our minimum security facilities. To say nothing of what I observed and the poor conditions in our medium security facilities or our assessment facilities or for our maximum security inmates. But the reality for Canadians is that what we expect is going to happen when justice is done isn't necessarily the reality. And we have seen this with I have a list now of examples of escapes that have resulted in more crimes being perpetrated on people in their communities. But that's why it's so important. We have to remember that our rights as Canadians deserve to be protected and respected. And when we have this imbalance that begins to take form, begins to take shape, where the rights of the accused, but also the rights of the convicted, of the guilty, are given higher order than those of their victims and those of innocent Canadians writ large. And I'm frankly not comfortable with that. And while there's a cry that this is some kind of hidden agenda, well, it's not very hidden. The leader of the opposition stood up in front of a room full of police officers and said, we think that there needs to be reform to some criminal justice laws. And then when pressed for more information, so that exactly the type of criminal justice reform that was previously proposed, where we would have consecutive sentencing for individuals who commit heinous crimes, that be restored. And we've seen Section 33 used before, and I won't pronounce on the acceptability of or the appropriateness of those uses, but I will speak to my comfort with this proposal. And I think that this is peak transparency. This is peak transparency to have a leader of the opposition in a minority parliament context tell Canadians, I'm ready for an election today, and also, if you elect me, we will stop putting the rights, the so-called rights of people like the individual I mentioned before, who perpetrated a heinous crime, that he needs to stay in maximum security. Shouldn't get out and shouldn't have the privileges that a medium security situation offers. I'm very comfortable with that. I'm very comfortable with that being the proposal by the leader of the opposition. And so it's imminently it's going to become more important, and it's eminently reasonable for us to pronounce what would we do. And so, should the committee make a statement that we recognize the importance of the Charter and that includes Section 33, the notwithstanding clause, to protect the rights of all Canadians, including their right to privacy? I could see us getting there. That's reasonable. I think that that's fair. But what I haven't heard after 9 years of the NDP Liberal government is them seek to repeal Section 33. So if there's this great discomfort with the notwithstanding clause, repeal it. You've been in government. You had a majority. Stacked the Senate with Liberal appointees. Just take it out. But there hasn't been any talk of that. Nor challenge of, depends on the province whether or not they want to challenge its use. So this is very important when we consider what kind of country we want to live in. And I'm very comfortable to say that I want to live in a country where people who commit the most heinous offenses stay in maximum security prison for their natural lives. And the beautiful thing about a democracy is for people who don't like that, they have the opportunity to have their say. That's beautiful. That's a beautiful thing about our democracy. Now, Mr. Kirk spoke very well about the contortions that one has to, bend themselves into to somehow say that everyone who voted for the bill to protect minors from pornography are somehow looking to further a digital ID, a single digital ID. I don't think that that's reasonable, but I don't think that the intention was that for this to be reasonable. It was supposed to be outrageous, but I'm not outraged. I'm happy to speak to it. The digital ID that the Privacy Commissioner talked about when he was here earlier spoke to a single digital ID to access government services. So for those of my colleagues in the bloc and in the NDP who are considering this motion, it's important to note that there has been no statement by the Conservative Party of Canada to require a digital ID to access content on the internet. That's patently false. So we often hear talk about being serious in our proposals from this committee and making sure that we're being logical and ethical, but that, of course, has never been said. What we've said is that minors shouldn't be victimized by companies who operate sites like the crime scene that is Pornhub. And we've talked in this committee about bullying, about online bullying, about the effects of social media on young people. And young people in schools have often seen revenge porn or the sharing of non-consensual sexual images of themselves being shared online and finding their ways onto these sites like Pornhub. And to say that we want to protect children from these very dark and truly dangerous places on the internet is this is what we've been transparent about what it is that we want to do. And to say that it's nefarious and that it's going to have some other purpose, like a one-size-fits-all digital ID, it's disingenuous. That's what I think that was the intention, was for it to be, again, outrageous and disingenuous. But, again, I'm very comfortable, and that's why I voted for the idea that it would be a requirement to have age verification to access pornographic material online, because it's necessary to protect children. And I can't see where the controversy is with that. There's never been any proposal. I think Mr. Kirk spoke to the number of options that have been discussed in the studying of the legislation. But there's no one serious or credible that said that the sites in question, like Pornhub, would be entrusted with people's personal information. As I said before, it's a crime scene, and what is allowed to go on there is criminal. So protecting children, I think that's reasonable. I think it's important. I think it's more than just a part of my job. It's as a parliamentarian, it's part of my job as a member of society, and so too, I believe it's a part of my job as a member of society to protect people from the types of heinous monsters who seem to find their way into minimum security and then go and commit capital crimes, the worst kinds of crimes like murder after walking off camp. And we're not talking 50 years ago. We're talking in recent years. So it's a question of what kind of place do we want to live? Do we want to live in a place where we have children being exposed to the sharing of non-consensual, sexually exploitive material that victimizes some of their peers and is monetized by monsters like those that run Pornhub? Can we take a step like requiring the use of age verification to limit the exposure, the risk for children? I think that that's important. And to try and conflate it into something else because there's maybe a belief that we wouldn't want to talk about it. I'm actually eager to talk about it. I think that there should be more conversations about what's happening to children and what our role is, and if we want to be complicit, because failure to take action when there's options in front of you, that would make one complicit. Like I said before, do I support the idea of making a statement to the House that we recognize as a committee the importance of the Canadian Charter of Rights and Freedoms, including the notwithstanding clause, or all parts of the Charter to protect the rights of all Canadians, including the right to privacy? Yeah, I think so. And I think I'd move an amendment to that effect, Chair. I'm not going to pull the trigger on that at this moment because I'd like to work on it. But that would be, I think that's where I would go with it. But with respect to the use of the notwithstanding clause, or perhaps, Chair, to add the context of the proposed use of the notwithstanding clause, like to make sure that that the type of monsters that I mentioned before, again, being vague just so as to not glorify the individual or the crime. I don't want to keep saying it because it truly is horrible, and individuals like that who perpetrate crimes like that need to be locked up for the duration of their natural life. So if we want to add the context of what the Leader of the Opposition's comments were, that's an amendment that I would consider, and I'd be interested if colleagues were interested in supporting just what he said. If they wanted to offer a quote, you can offer a quote from me because I've made them in the House and outside the House, specifically with respect to the use of the notwithstanding clause as proposed by the Leader of the Opposition, and also context on the use of age verification to protect children from both pornography, but also the sharing of non-consensual or sexually exploitive materials. I think that the context in those both of those examples would be useful.
Sorry,
Further,
Mr. Barrett,
yep.
you're gonna have the floor. I'm gonna suspend for 5 minutes because I have to confer with the clerk. So I'm gonna suspend for 5 minutes, and then I'm gonna come back to you after that if you don't mind.
I'll work
sir.
on my amendment.
Okay, thank you. please.
Move to adjourn.
Move to adjourn? Okay. We have a motion to adjourn the meeting. So, do we have consensus to adjourn the meeting? No? Okay. So I'm going to call the vote, Madam Clerk, if you don't mind.
The vote is on the motion to adjourn the meeting. Mr. Baines,
No.
Ms. Damoff,
No?
Mr. Fisher, Mr. Fragiscato, sorry,
No.
Mr. Housewater,
No.
Ms. Khalid,
No.
Mr. Barrett,
Yes.
Mr. Brock,
Yes.
Mr. Kirk,
Yes.
Monsieur Villemur,
Oui.
Mr. Green,
No.
yeas 4, nays 6.
Okay, so the motion fails. Mr. Barrett, you still
Yes.
have
Chair.
the floor.
I just thought since it was the end of our scheduled time, it's 1:30, that I heard folks had places to be. Look, while I have an amendment to prepare, I just want to summarize my comments.
A point of order, Chair.
Go ahead on your point of order.
Thanks, Chair. I thought that we had suspended so that Mr. Barrett could draft his amendment, because that was what our last wording was.
Suspended because I had to confer with the clerk, which I did. I resumed the meeting, gave the floor to Mr. Barrett. Mr. Barrett still has the floor. That's the reason why we suspended. Go ahead, Mr. Barrett.
So I just want to summarize, Chair. There's
Point of order? This is out of curiosity.
Yeah.
So it's of no personal offense to Mr. Barrett, but I'm just curious, when a motion to adjourn happens, would that not be the final, would that not mean that the member would have conceded his time to the speaker's list and it would go to the next speaker? Like, how do you move a motion and keep the floor procedurally?
That is a very good question, Mr. Green. I'm just going to.
I'm full of them, sir.
Yeah,
So
no,
we're keeping attention here.
I'm going to confer with the clerk, so just give me a second here, okay? Okay. You know, we still, like, I'm honestly not sure about that, Mr. Green, so I'm going to, just going to consult with the clerk. But in the meantime, Mr. Barrett has ceded the floor. He's given up his time, and so I am now going to go to Mr. Brock, and I will come back with a ruling on, or not a ruling, but some guidance on that. Thank you, Mr. Green. Go ahead, Mr. Brock.
And I'll, thank you, Chair, and I'll allow you to be mindful of the clock. I know we have resources till 2 o'clock. I probably have at least 2 hours worth of commentary and material to read out. So that being said, yes, thank you. So I start by sharing the initial commentary from my colleague, Mr. Keurig. Just how disappointed that he was to hear the commentary from Ms. Khalid in terms of the framing of her motion, and how shocked she was and how disturbed she was. You know, the hypocrisy from that member, and quite frankly the entire Liberal bench, on these two issues is just astounding. The lengths they will go to try to change the channel on where public opinion is with the Liberal Party of Canada and their leader, Justin Trudeau. It really speaks to how low they have sunk and the attempts that they will do and try to fearmonger, to frighten and scare Canadians. Pretty much the entire playbook of the Liberal Party of Canada since Justin Trudeau became leader of the party, literally in 2013. It was all about scaremongering. Even before 2013, one can make the argument, going back to the 2004 and 2006 election under PM Martin and Chrétien, the lengths by which they will go to try to paint any leader of the Conservative Party of Canada as a boogeyman. And that Canadians ought to be fearful that there is somehow a hidden agenda, that they will say one thing and quite frankly do another, which really is the playbook of Justin Trudeau and has been since he formed government in 2015. But it's more pronounced now because, let's face it, they're down 20-plus points in the polls. They have been down for well over a year.
Chair.
Go ahead on your point of order.
Just talking about relevance, I'd encourage the member to come back to the topic at hand.
Go ahead,
And
Mr.
relevance
Brock.
is very subjective, as I telegraphed to the party. My speaking remarks are at least 2 hours long. So I will get to relevant points of Ms. Khalid's motion in due course.
Mr. Brock has the floor. Go ahead, Mr. Brock. And I'm not going to accept any interruptions here. We've talked about this many times. Relevance is subjective. Mr. Brock will get to his points and make his points in an appropriate manner, and I don't want any interruptions unless it's related to the actual standing orders, and you can cite those. Go ahead, Mr. Brock.
So before I was interrupted, Chair, I talked about the Liberal Party of Canada's standing amongst the Canadian electorate, and a number of polls have been conducted literally since the day our leader had been elected, and there has been a consistent drive to water down and eliminate that Liberal support. And it's obviously must be extremely disappointing to many longstanding members of the Liberal Party of Canada. It's not surprising that we have a number of ministers who've decided not to run for re-election. We have a number of MPs deciding not to run for re-election. There is a phrase that I'm not going to use, but it's clear that they too look at the polls and they know that public opinion is changing. It's changing for a number of reasons, Mr. Chair. There's always, and always has been, a shelf life for any political party. That applies to the Liberal Party, that applies to the Conservative Party. People get tired of being promised a number of things pre-election merely to buy a vote, and then to be profoundly disappointed when the Prime Minister of the day does not deliver. And that's precisely what's happening with Justin Trudeau. I'm sure he and the Deputy Prime Minister, Chrystia Freeland, and the entire Finance Department, if not the entire Liberal bench, thought that the spring budget would finally end some negativity towards their economic policies, that they were going to make it fairer for a number of generations, that it wasn't strictly about the middle class. Now it's fairness for multiple generations. But what are we seeing in the budget? We're seeing the same worn-out talking points that Justin Trudeau promised Canadians in 2015 and completely has not delivered on, particularly in the area, in my view, of public safety. And I'm going to get to relevant points in due course. But it's just indicative, emblematic of why this party and its members are just so desperate to find something other than to take a look at their track record. The budget has fallen flat on its face. One could have made the argument that the Prime Minister was going to drop the writ 2 or 3 weeks ago with his cross-country tour and all his ministers following along and delivering all these little goodies as to what they can expect from the budget. But nothing has moved the channel because Canadians are wise and Canadians are intelligent. And they have finally realized that this Prime Minister, who they thought was going to conduct governance so much more differently. Let's all remember his famous words in 2015, how he would do politics different, that his administration would be known as the most transparent, accountable, and responsible government this country has ever seen. But then you take a look at everything that has transpired. Their non-willingness to provide documents at committee, instructing their members to filibuster when it comes to exposing elements of corruption and unethical behavior. The list goes on and on and on. I could spend hours doing a deep dive, just taking a look at the number of scandals that has rocked Justin Trudeau and members of his cabinet, members of his backbench, literally since 2015. Canadians are wise individuals, Mr. Chair, and they remember these things. So with all the good efforts that the Liberal members of this committee are trying to do now, trying to scare Canadians and fearmonger, in my view, is going to fall flat on its face. Let's take, for instance, this whole concept of the scariness of the notwithstanding clause. The notwithstanding clause, surprise, surprise, introduced by Justin's father himself, Pierre Elliott Trudeau, well over 40 years ago. And that notwithstanding clause in the last 40 plus years has not been amended. It has been in the books for a very long time. And while no federal government has exercised its use, does not necessarily mean, in fact, I'll say definitively, does not mean that it's inappropriate to use it in the future. We know that some provincial premiers have used it. You know, and where was the backlash from Justin Trudeau? Well, I guess there was a little bit of backlash. He talked a good game, but he didn't do anything about it. When Doug Ford, Premier of Ontario, talked about it, when the Premier of Quebec talked about it, this is something that is law in this country. And for all the non-lawyers on the Liberal bench, I invite them all to take the time, it'll take you less than 2 minutes, to actually read Section 33 of the Charter. That when used, clearly, and I'm just paraphrasing it, when used, it's not permanent. It's reviewable at 5 years. So when we take a look at the comments recently made by our leader, these are comments, Mr. Chair, that have not changed or been altered in any which way from the first moment that he talked about the applicable use of the notwithstanding clause. The notwithstanding clause, despite the best efforts of Ms. Khalid to try to open up the floodgates and widen the potential abuse of the notwithstanding clause to scare Canadians to be fearful of the use of that clause, because now it might be applied to reproductive rights, is an absolute joke. And it's offensive, because she knows full well, as does every member of that Liberal bench, where the Conservative Party of Canada stands on that issue. Dead stop. No further discussion needed. But that won't stop the Liberals. That will not stop them. They will continue to scare Canadians into believing that Prime Minister Pierre Poilievre, and yes, I will say it with complete confidence, will be Canada's next great Prime Minister, will use it, if he uses it, and when he uses it, will use it for its stated objective. And his stated objective is to correct a lot of things that are happening in our justice system that is really, really disturbing, not only to members of Parliament, but disturbing to Canadians as a whole. And I want to spend a little bit of time talking about the Bissonnette case, because that really forms the genesis of our discussion regarding the notwithstanding clause. And I want to read an article from the press. This is dated February the 8th, 2019. And this is some of the important words used by the sentencing judge in Quebec before the government decided to appeal. And the heading reads, Quebec City mosque shooter sentenced to at least 40 years in prison. Judge calls Alexandre Bissonnette's attack an unspeakable tragedy that tore apart our social fabric. Bissonnette, who pleaded guilty to killing 6 men at a Quebec City mosque 2 years ago, will be allowed to ask for parole at the age of 67, a judge decided Friday. Bissonnette, 29, will serve an automatic life sentence for shooting and killing the men at the Quebec Islamic Cultural Center on January 29, 2017. He has been behind bars since the shooting. He will be allowed to go before the Parole Board of Canada after serving 40 years, ruled Superior Court Justice Francois Huot, in a decision that left survivors and families feeling disappointed, dismayed, and gutted. I'll go back to those words, Mr. Chair. The judge called Bissonnette's attack an unspeakable tragedy that tore apart our social fabric. During a sentencing hearing that lasted nearly 6 hours, the judge read out parts of his 246-page decision, and I'm sure that members of this committee would not like me to start reading all 246 pages, but I'm certainly happy if necessary, to a packed courtroom describing Bissonnette's actions as premeditated, gratuitous, and abject. His crimes were truly motivated by race and a visceral hatred towards Muslim immigrants, the judge said. Bissonnette was emotionless as the judge read out his decision and was quickly escorted out of the courtroom. After a grueling day, survivors like Said El Amari was visibly upset by the outcome. He choked down tears of anger as he spoke outside the Quebec City courtroom. He said, "Today is a sad day. We are committing 17 orphans to 40 years of suffering, at the end of which they will have to show up again to keep this assassin behind bars. That suffering starts today and will last 40 years. I am floored." Amen Derbali, who was hit by 7 bullets and is now paraplegic, said he almost fainted. He almost fainted when he heard the judge's final decision. "I would have liked to see justice served today," said Derbali. Megda and Amir Belkacemi, who lost their father in the attack, extended their support to the families of the victims of Bruce MacArthur, who was also sentenced today on 8 counts of first-degree murder with a chance of parole in 25 years. Earlier in the day, Justice Holt did a minute-by-minute run-through of the shooting. And it's important that I read this out because I'm going to compare and contrast to the ruling of the Supreme Court of Canada that deemed this cruel and unusual punishment. Armed with a .223 caliber rifle and a 9mm Glock pistol, Bissonnette was carrying 108 bullets when he entered the Islamic Cultural Center, shooting into the crowded prayer room as Sunday prayers were ending. And again, they've identified the names of those that died, and then 5 others were critically injured. Bissonnette pleaded guilty in March 2018 to 6 counts of first-degree murder, 5 counts of attempted murder for the men he wounded, and a 6th count of attempted murder for the 35 people present that night, including 4 children. Both the Crown and Bissonnette's lawyers said they have to review the lengthy sentencing decision and would not be commenting. While first-degree murder carries an automatic life sentence, the judge had to decide how long Bissonnette would have to wait before he would seek parole. We all know in 2011, Stephen Harper's Conservative government adopted Article 745.51 to the Criminal Code, which allows a judge to impose consecutive rather than concurrent periods of parole ineligibility for multiple murders. And for the Canadians who are watching these proceedings, and I'm really glad that we are public and not in camera, because Canadians deserve to hear this. Consecutive means just that there was a potential that Bissonnette could have served 25 years for the intentional, premeditated killing of each member of that mosque. 25 times 7. He would have died in prison. He would have been carried out in a box. Concurrent is the opposite. In essence, what the Supreme Court of Canada has done is it's granted legal license to mass murderers, telegraphing to all mass murderers that regardless of the number of victims, regardless how you kill those victims, regardless of your background, you have got a license to mass murder innocent civilians in this country, and you will serve a maximum of 25 years before you're eligible for a chance at parole. Because the wisdom of those 9 judges, not too far from here, at the Supreme Court of Canada, deemed that having a life sentence, that really means a life sentence. These are the words that had been entrenched in the Criminal Code of Canada for decades. A life sentence. Our learned judges of the Supreme Court of Canada found that 40 years, Mr. Chair, not 25 times 7 years, I'll quickly do the math, 35, 175 years. That 40 years was cruel and unusual because it denied this animal, this mass murdering animal, the opportunity to re-victimize every single family member and extended family member of the 7 people that he killed. That I find, as a member of the Ontario Bar, profoundly disappointing. Absolutely profoundly disappointing. I had to think about the Bissonnette decision, Mr. Chair, when I was a member of the Justice Committee. And we were studying victims' rights. It was coincidental at that time, the Bissonnette decision, the Supreme Court of Canada was released. And we invited 2 victims during one particular day of our study. And these victims, I wish I had the transcript so I could actually share the extremely profound language that they used, but their appearance at justice was perhaps a week to 2 weeks following the release of that decision. And I remember one case in particular. I don't know if any members of this committee remember the case, but the accused, now the convicted murderer, was a man by the name of Dylan Millard. And he and another co-accused, also a convicted murderer, decided to answer an ad for a gentleman, a young father who recently got married and had a young family and lived in a rural part of just outside of the city of Hamilton, Ontario. He answered an ad for the sale of the victim's pickup truck. And this is probably a warning to Canadians as a whole, and I'm sure that people are taking appropriate precautions as a result of what happened in this particular case. So the 2 killers arrive at the residence of the victim, and at the time he's holding his baby, a baby that has been denied the opportunity to really know her father. She literally was under, I think, 1 year of age at the time. And they pulled up, and what they did was actually, which should have been a red flag in hindsight, but whatever vehicle they used, or whether they were dropped off at the residence of the victim, they ultimately walked up his driveway. It was a fairly long driveway. And they said, we're interested in following up on your ad for the sale of your truck.
Mr. Brock?
Yes?
I hate to do this, but I'm going to have to cut you off.
I'm very disappointed in that, Chair.
Sorry,
because
we've run out of resources.
This is a great story I wanted to share.
I am adjourning the meeting. Thank you.
Thank you.
Jim, excuse, I didn't name me.